when I'm done, I can give this one out, and then I can give one to you. So, my name's Steve Roush. I'm an attorney. Don't hold that against me. I've been in practice now since 2003, so 17 years. My primary practice is in estate planning and business formation, merger acquisitions, asset protection. I specialize in that. My goal is to help clients to be able to figure out how to structure themselves both from a business standpoint as well as a personal standpoint to avoid all the heartache and all the risks that come with just living in the world, right? And so, but from your guys' standpoint, we're really looking at how do we help you to be able to deal with those risks that you run into as property owners and property investors, right? And then those risks come from everywhere, right? From bad tenants to property issues to governmental regulations to your health. So we have all kinds of different things that come at us as property owners. And so the goal is to make sure that you're structured appropriately, that we have all the features in place to be able to protect you if you get sued, and to be able to transfer those assets when your health declines or you pass away to the people that you want it to go to. And so with that, then feel free to ask any questions as I talk through this, but really what we're trying to accomplish is when we look at how do we advise clients to be able to make sure that they're maximizing protecting themselves, it really goes back to how you own your assets, right? And generally, as you know, there's basically 6 different ways to own property. You can either own it in your individual name, which is just a fee simple ownership, okay? You can own it as a tenant in common. You can own it as a community property asset. You can own it as a joint tenant with right of survivorship. You can own it under contract or in a trust or an entity of some kind, okay? So those are the 6 different types of ownership that we look at. And ownership drives everything in my world. It really dictates how we deal with things. From a standpoint of how do we analyze for you how to protect your assets. If you own something in your individual name, you're exposed, and all your assets are exposed. And so we want to make sure that you understand that, number one. Some people are very comfortable. I had a gentleman in, it's been 2 or 3 months ago, and he's got, I don't remember how many properties, 13 or 14 different properties, individual single-family residences that he has as rental properties, and he owns them all in his individual name. And I said, okay, do you understand the risks that are associated with this? He's like, yep. He says, I have a $5 million umbrella policy, and I hope that that's going to cover me. And I said, all right, I hope it'll cover you too. The big risk that we run into is catastrophic risks, right? You have a furnace that goes bad and people die from carbon monoxide poisoning, right? That's a catastrophe. That's going to be a multi-million-dollar lawsuit. And hopefully you have insurance that's going to cover that multi-million-dollar asset that you're going to lose, because if it's your property and you didn't maintain it, the jury's going to find you responsible. And so your insurance company's job is to step in, represent you, and protect your interest. But if it exceeds that, if that judgment exceeds that, then they're looking at all your other assets. And if you own those all in your individual name, they're all exposed, right? And so, it's just a matter of looking at all your assets and then deciding, what's my risk tolerance? Am I okay with that? Or do I want to take and I want to structure it differently so that I can isolate the risk, Because if you decide that you want to, you own a rental property and you put it in an LLC, and something happens to that LLC, even a catastrophic issue, well, the only thing exposed is what's in that LLC, right? And your insurance policy is going to step in and do what it can, but they don't get to come outside that LLC as long as you've structured it correctly, okay? And so that's really why one of the reasons that LLCs came into existence was to provide business owners the capability of being able to do business in an entity that was similar to a corporation from a protection standpoint, but flexible from a taxation standpoint. And so that's why Wyoming was the first state to kind of come up with the idea of LLCs. And since 1977, they've been kind of a factor in how we do business. When I first started practicing law, even before that, I worked for a large law firm. My primary job was setting up entities. The traditional thing was set up a corporation. Well, as LLCs became more, the IRS started to work with them more easily. LLCs became the entity of choice. And so now, no matter what we do, usually we set you up as an LLC. Even if we're going to have you operate as an S corporation at some point, we're still setting you up as an LLC because it's just such a flexible entity to use. But when we look at it, there's many different entities that we can structure you in. You have sole proprietors, partnerships, okay? When we talk about partnerships, general partnerships, terrible way to do business, okay? Because in a general partnership, all the partners are jointly and severally liable for your partner's decisions. So your partner can be out there doing something and you're responsible for what that partner did. And so it's a terrible way of doing business. And so that's why we have limited partnerships, limited liability partnerships, and limited liability limited partnerships. You got these different L's in front of your partnerships. It was to risk tolerance, right? To protect people from their partners, but yet get that taxation issues that we need. With property owners, you want the ability to pull that property into and out of that entity without it being a taxable event. And with a corporation, it doesn't work. As soon as you pull it out of that corporation, it's a taxable event. You put it back in the corporation, it's a taxable event, right? LLC is not the case. You can pull it in and out of that LLC without it being a taxable event. And so it's just a nice tool to use. Sometimes we still will use a limited partnership or a limited liability partnership, but oftentimes we're using LLCs, just simply because we know how those work and what we need to do to structure them. One question that often comes up is, well, can you use trusts? And trusts are an interesting dynamic because trusts were developed roughly about 500 years ago in Old England. And the concept of a trust was the wealthy landowners at the time didn't want to go through the king's court system to be able to pass their assets down to their family. And so they went to Parliament and said, is there a way that we can avoid having to go through the king's court system? And they said, yeah, absolutely. We'll allow you to do this trust relationship. And at that time, it was literally that. People would take their assets, they would entrust them to a trustee and say, I want you to hold on to these for the benefit of who I need them to go to when I'm no longer here. Well, then over time, we developed trust agreements. And then when we became a country and we kind of wholesale brought over the British system of law, the wealthy families in the United States figured out a tool. In the United States, they've kind of revolved around generally three different types of trusts. You have revocable trusts, which are strictly an estate planning tool, okay? Revocable trusts do not provide you any protection. It's simply a tool to avoid probate when you die, okay? Irrevocable trusts, which by its very name, irrevocable. Once you've signed it, that paperwork's in place, you cannot change that document. It is what it is. So it can provide you some asset protection. We use it for purposes oftentimes of trying to qualify for certain types of benefits, Medicaid benefits, sometimes other types of benefits. We use it oftentimes for special needs. If we have an individual who has a disability that we're trying to protect them, we're generally setting it up as an irrevocable trust. And then there's all kinds of charitable trusts that you can set up. Charitable remainder trust, charitable lead trusts, and those are different esoteric types of trusts that are used to avoid estate taxes and to do some asset protection. And so one of the questions that comes up is that, and I had this just not too long ago, I had a client that came in, he said, my sister and I are working on a deal, we want to put a property into an irrevocable trust. Our sister is disabled. We want her to be able to live in that house, and we'll be the trustees of the trust, and she'll be able to realize the benefit of that through her lifetime. But then if she dies, that property comes back to us, and then we want to build in a whole bunch of language that says that our creditors can't come and take that from us if we file bankruptcy or we get sued for some reason. Well, that doesn't work. You can't create a trust, irrevocable, revocable, doesn't matter, and put your own assets into it and say, oh, if I get sued, creditor, you can't come and get it. Fraudulent transfer rules step in and say, no, we're not going to allow you to do that. It's basically committing a fraud, okay? But some states, Nevada particularly, here in the western United States, has taken the stance that they will allow what are called domestic asset protection trusts. What we don't know is whether those will work here in Idaho. We know that they work in Nevada, but we don't know how an Idaho court would deal with it if that trust was sued in Idaho and it owned an Idaho property. Is that Idaho court going to say, oh yeah, we're going to recognize Nevada protection laws on that property? And so they've been in existence about 10, maybe 15 years, but we just don't have any case law, so we don't know. But there's some advocates out there to use those. The big downside to those type of trusts is you have to give up control. You have to hire a professional trustee to manage it for you, and you can't have any control over it. Then generally there's a very short statute of limitations period once you put the assets in there. If you get past that year statute of limitations in Nevada, then generally the assets are protected against creditor claims. And so as we in the legal world come up with these esoteric ways of trying to protect assets, it's one of the tools that comes up, but we just won't know until it's tested in court. Yes?
So with the example of them wanting to protect this house for their disabled sister, so the issue wasn't because they were the trustees of the trust. The issue was because they eventually could be the beneficiary when they die.
Correct.
Because, okay.
When she dies, right? So they had created this basically as a gift trust, right? Their gifting trust, where they said, listen, we're going to create this trust, we're going to put this property in it, and we want our sister to be able to realize the benefit during her lifetime. But when she dies, we want it to come back to us, but we want to be able to shield it basically from bankruptcy and creditor claims. Well, you just can't do that.
Okay.
Creditors, bankruptcy courts aren't going to allow you to do that. Creditors are going to cry foul saying, no, that's a fraudulent transfer. It works great for the disabled sister though, because the disabled sister can live there, she'll have someplace to live. It's not her asset. And so she'll still be able to qualify for Medicaid or any of these other government benefits. Yeah.
What if the beneficiary was one of their children instead of them?
So that would potentially work, because then it's a third-party trust. It's a trust that was created by them, but the beneficiaries are their children. And so third-party trusts actually have excellent asset protection. So when we do revocable trusts for estate planning purposes, part of what we're doing is when that original trust maker or grantor passes away and they leave it to their family, they create a third-party trust at that point. So their children, when they receive it as a beneficiary, those assets are absolutely protected against creditor claims. And so it's a matter of us looking at it and figuring out what the best way to structure it is. Generally for you who are the asset owners and you're trying to protect your own assets, it's layering. What we're trying to do is put entities upon entity in place to make it such of an administrative pain for that creditor that they come to the table and want to negotiate to settle it. Yes?
How many properties do you recommend being in one LLC?
Well, as an attorney, I would say you want one per LLC, but that's not reasonable oftentimes. And so as an attorney, I would say I wouldn't put more than probably 3 in any one LLC, and just make sure you've got really good insurance to cover it. I do have a handful of clients that have put an LLC in each property in one LLC, and they just manage it that way. They have about 20 LLCs, but it can become an administrative nightmare to deal with that many, LLCs and trying to keep track of that many bank accounts and, and making sure you're covering yourself that way. So I have a handful of clients that I say, let's put 2 or 3 in that LLC. Just make sure that we understand the property, the age, the maintenance history, all those types of things, and then the tenant, who you're putting in there. Make sure you know who that tenant is, and vet them very carefully. That's how part of the ways that you actually protect yourself is by vetting who you put into your properties. Make sure that the people you put in there are generally upstanding people. Now, nothing's going to be perfect. People have life events, and at the end of the day, when they're trying to decide between am I going to pay my rent or am I going to take care of my family, they're generally going to opt to take care of their family, and so they may then default on their lease, and you're going to have to evict them. It's just the nature of it. But if you vet the people that you put in there, and you're pretty confident they're generally upstanding people, they're not going to be trying to sue you over little petty things, slip and fall cases, or those type of things, which just cause more headache for you as a property owner. Yeah.
This is wildly off track, feel free to say so, but
That's okay.
Airbnbs, where you don't even know who's in there, they're in there 3 days, 7
Right.
days, come and go. What are your thoughts about how to protect yourself?
On Airbnbs, I would say, you want to make sure that they are in an entity separate from yourself. And then what I've seen is the insurance companies are starting to come up to speed on Airbnbs and are designing specific type of insurance products for those to be able to protect you as the property owner as well as their interest. So I'd say just make sure that you've structure in a separate entity and make sure that you have good insurance on there.
We had another LLC question from the interwebs Brad,
Sure.
who's watching us from Thailand. Do you remember when Brad spoke on his way to Thailand, everyone? Shane, his question's about LLCs and 1031s.
Yeah, he had a question. Does holding a title and a rental using an LLC cause issues when 1031ing its sake into the replacement property from a lending and contract standpoint?
It depends. It depends on whether or not that LLC is owned by multiple people or not. If it's like, for example, an LLC that's a partnership where you have independent third parties that are owning it, that can create more of a headache on your 1031. If it's generally just you and it's your LLC, you're the only owner, generally you don't have as many problems with 1031s with an LLC. Same thing with trusts. I have clients that have trusts that own property, they're doing 1031s. Same thing, as long as the 1031 facilitator can understand who the ultimate person is that's the owner behind it, we generally don't run into problems with them.
And on that same note, from a real estate purchase and sale perspective, I do a lot of these transactions, and a lot of times what happens in practice is someone will buy a house, quick claim it into an LLC, and then when they go to 1031 out of it, they have to then make sure that the property that they're purchasing is also in an LLC.
Right.
But lenders don't like lending to LLCs.
They don't.
And so if that doesn't work because of a lender perspective, then what they'll do is what we call the drop and swap. I don't know if that's a technical term,
Yeah.
but it's where you have title in one name and then swap it before the sale. So you swap it out of the LLC name back into the personal name, and then you buy the new property in the personal name and then put that one in the
Put it in
LLC.
the LLC, yeah.
Have you seen any repercussions from that sort of footwork?
No, actually, and that's the way to do it. I
Okay.
mean, as a matter of fact, lenders are notoriously, they don't like to lend to trusts, they don't like to lend to LLCs, because ultimately at the end of the day, they want that they have some skin that they can come after if you don't perform, right? And so I have lots of clients who have properties in trust. We have to deed it out of the trust into their individual name to do refinancing. I mean, so it is kind of a pain. I have had on a handful of occasions, I have been able to convince lenders, especially when it's an LLC there's only one underlying owner of that LLC, member of that LLC, that it actually protects the lending institution, because all those other outside creditor claims are going to, they're going to protect the bank. The bank sits in first position, so, but they're just notorious in being skittish about wanting to lend to entities. So it's just the nature of it. I think part of it, honestly, was the Patriot Act. I think when we had the 9/11 and Patriot Act came into place, the trusts that were being used to funnel a lot of the money into the United States for those terrorist organizations were in charitable trusts. And so when Congress came through and passed the Patriot Act, there's all this language in the Patriot Act about trusts and what banks have to do to verify who the underlying owners are of those trusts. And I think that has rolled over to entities, LLCs and other entities. So, yeah.
Another question, since we're on this LLC kick here. Owning different properties in different states. Do you recommend having an LLC? So let's say I own one here and I own one in Wyoming. Is it beneficial to have an LLC established in Wyoming, or is it fine to just still own that property with an Idaho
With the Idaho
LLC?
entity?
Yeah.
It's a great question, and it kind of depends. First of all, Wyoming's a great state to have an LLC.
I just picked that one at random.
Okay.
Just,
But
so
it's a great
it
state
is-
because there's some great asset protection features with Wyoming as well as Nevada. Okay, but it depends on the state. So for rental properties in particular, your biggest risk is somebody suing the entity, right? It's not so much them suing you as the underlying member. And so Idaho entities from that standpoint are very good. We have some great case law in protecting the underlying owners. Then it just depends on the state. Some states require that if you're going to own a property in that state with a foreign entity, so an Idaho entity owning a Wyoming property, they're going to require you to register the Idaho LLC in that state to do business, right? And so it's just an added expense that you have to go through. But some states don't require that, you know. Idaho in particular, they do not require you to have to register that foreign entity in Idaho just to own the property. Idaho's kind of nice that way, but some states do have that requirement. So it's more from that standpoint. There was also, go ahead.
Excuse me. Single member LLCs, do they still truly receive asset protection, or is the corporate veil pierced and they just look at that as an extension of your personal finances, even if you have a separate account for the LLC and all that? I mean,
It's a great question. So it depends on the state, and it depends on the region of the country. Idaho isn't great. We have a bankruptcy court opinion here in Idaho, U.S. bankruptcy court opinion that said that the bankruptcy trustees in the state are going to look at single member LLCs and say, we're going to disregard the entity. We get to the underlying owners of the LLC if it's a single member entity. Same thing with Denver. Denver's got a bankruptcy court opinion, or Colorado's bankruptcy court opinion, the same thing, where they've said, we're just going to look at that and say that that's just you. We get to you. The language of those cases say, even if you had a scintilla of ownership of somebody else in those LLCs, then they wouldn't be able to disregard the entity because somebody else has an ownership in that. Now, Wyoming, interestingly enough, has taken a stance statutorily and said they're going to have a public policy that says that the state will not recognize bankruptcy court opinions against single member LLCs for that purpose of being able to maintain the asset protection features of a single member LLC. So when we're looking at it and we're really concerned about single member LLCs, we look at Wyoming because Wyoming has taken that stance. And so we use Wyoming for a bunch of different aspects of things. If I have doctors or dentists or those type of professionals that I'm working with that have high incidence of maybe malpractice liability, we look at Wyoming or Nevada for use of their LLCs because the exclusive remedy to a creditor is a charging order, right? All that means is they get to stand in line and receive a payment out of the LLC if the LLC ever distributes anything. In Idaho, the problem we have here in Idaho is that there's a foreclosure provision in the Idaho LLC statute. So if a creditor says, well, I don't like the fact that I have this charging order and the member of or the manager of the LLC is not distributing out of that LLC, they could go to court and ask the judge to foreclose the interest and then give them the LLC interest. And so I don't like Idaho from that standpoint. But we haven't ever had any creditor take it that far in Idaho. So we don't know how the courts are going to deal with it yet.
Would a trustee or the beneficiary of would own, if they own part of that entity, so it wasn't a single member entity?
Single member
Is that
LLC.
substance over form if it got?
Yeah, because well, depends. Depends on what kind of trust it is. If it's just a revocable trust and you own an interest in it and then you own an interest individually, they're just gonna say, that's you, right? Revocable trust. But let's say that you're a beneficiary of a third-party trust. So, or your parents set up a trust and they, gave you, and that now owns the interest and you own the interest. Well, to the extent that that trust that you are a beneficiary of owns that interest, that's gonna be protected for you, whereas the interest in your individual name may not be. Any questions? There were some other questions that you guys sent me in an email. So one of them was, can a person under 18 legally own real estate? And the answer is no. And so what happens in that scenario is the better thing to do is create a trust where that minor is a beneficiary of that trust and have the trust own the property. And so that's generally how we deal with that. Now, I have had the scenario where somebody did a quitclaim deed and transferred ownership of a property to their 4-year-old grandson and then needed to refinance. Well, now how do you get a 4-year-old to be able to sign a document? They can't. So they had to go to court, get the judge to appoint a special administrator to be able to administrate that ownership interest on behalf of the 4-year-old, because the parents can't do it. Parents are simply parents. They don't have the legal authority to transact that. Now, it was the parent that got appointed, but they still had to go through that process to get the appointment. And it was a grandparent that did it, and they just didn't understand that you can't do that, that the child can't sign, so they can't contract. So it creates an issue.
So I do hold properties in trust, and I do have young children that are beneficiaries. If something happens to me, do I need to have somebody as their supervisor to?
Just a successor trustee that's going to manage that trust for their benefit. So that's generally with a trust. You're usually the trustee when you first start it, but if something happened, you want to have somebody's successor to be able to step in and manage it for their benefit. It's the same thing. I get clients that ask all the time, can I have my minor child be a member of my LLC? Well, no, because that's a personal property asset. They can't own it. People do it all the time, but they shouldn't do it. And so, because if we needed to do anything, that child can't sign. They can't contract. It's the same reason that you're not going to find a car dealership that's going to sell a car to a minor. Because as soon as that minor tries to sign the paperwork, well, that's a voidable contract. So they can't be held responsible for the note or the loan on the property, on the car. So, any other questions on that? Okay, here's a good one. When you have an Idaho court ordered judgment against a person or persons, how can you legally track them and their assets from state to state? And does the judgment follow them from state to state, or is there some way to register it federally? So, short answer is, you can get a judgment. Can you legally track them and their assets from state to state? Yes, there's a process you have to go through. So you have to take the Idaho judgment, and you generally have to register it in the state in which they are now located. So you go to the court in that state, and you ask that court to recognize the Idaho judgment, and they'll issue an order in that state, and then you can go and register, and record that in the county where they're locating, and then that's a valid judgment. There is no, so it doesn't automatically follow them state to state. So you have to actually take that judgment and register it in the respective states. And then there's no federal registry. So there's no like Secretary of State's office or anything like that you would be able to register that. It's just you have to go to each state and track them down. I had a similar situation years ago here in Idaho. So judgments in Idaho, you get a judgment and then you go record it in the county in which you think that person has assets. And then that judgment sits as a lien against any asset they own in that county. But you have to go to every county where you think they might be in Idaho and record that in every county for that to be valid in every county. It's not just a statewide judgment. So it can be a pain. Let's see. At what point should one convert from holding real estate in LLCs versus a trust, and how expensive is a trust to maintain? Actually, what we do is we actually use trusts and LLCs in conjunction with each other. Generally, you have a trust for purposes of estate planning, to avoid, if you die, having to be in a probate proceeding. And then we use LLCs to own the assets, whether that's real property, investment properties, or whatever it may be, as an asset protection tool. And so we use them hand in hand. It's not generally one versus the other, although you could do that. You can own assets in a trust, you can own assets, and you could create, so a revocable trust is generally what we use for purposes of estate planning, but you can have as many type of trusts as you want. So you could create a trust that is just simply for the purpose of investing. And you just have features in there that says if you die, this is who you want it to go to. And so you could do that. You could set up an LLC that's just for a trust that's just for investing purposes. And then you could have a trust that is for estate planning purposes that is the beneficiary of that trust, or the trust that has the asset in it is a benefit, or that trust is the beneficiary of that. So you can layer those just like you can LLCs. And if it's a revocable trust, it's just tied to your Social Security number. So there's no separate tax return. There's no separate, filing that we have to do. It's only at your death that the trust may have its own EIN.
With multiple trusts, and I have individual bank accounts for each trust, is there a way to simplify the bank accounting to have one bank account that can have multiple trusts in it, or do you have any idea on that?
Generally, no. I mean, it's generally up to the institution. The institution's going to have their own rules and regulations on that. But my experience has been that, let me back up. You could have one, if you have a trust, you can have as many bank accounts in that trust as you want. But I don't think they'll allow you to say, well, I've got 5 different trusts and I can funnel everything into one bank account. The institution's going to want you to have a bank account for each trust. Yeah. It's the same thing with LLCs, right? From a protection standpoint, if you want your LLC to actually do what you intended to do, you need to have a separate bank account for that LLC so that your rents are coming into that bank account, and then from there it can go wherever you want it to go. So there's some, in Idaho, there's 3 factors that courts look at to decide whether they're going to pierce the corporate veil. The first one is formalities. They want to see whether you formed it correctly, meaning you filed the appropriate documents of the Secretary of State's office. Do you have an operating agreement? Do you have subscription agreements, membership certificates, meeting minutes? They want to see all that because they want to see that you've treated the entity separate from yourself. The second factor is, do you have a separate bank account? No commingling of funds. That's a big one. That's the quickest way for you to lose for a court to invalidate an entity is if you've been treating that entity and you've been using your personal bank accounts as the bank account for the entity. And the third thing they look at is capitalization. Have you properly put enough money into that entity for it to be able to satisfy its obligations on a monthly basis? Most businesses, when they start up, they're just bootstrapping it, right? They don't have a whole lot of money. But as long as you can show that you put some money into it and that you've got some insurance to cover the things that you have obligations for from a general liability standpoint, that's going to be sufficient on the capitalization side. And the court generally looks at the capitalization less, they weigh that less than they do the other 2.
I have a small question.
Oh, yeah, sure.
So, I have an LLC and I've got monthly rents coming in. Suppose I want to buy another investment property. Would it be considered commingling of funds if I took money out of the LLC that I have for my existing investment property to use as down payment for another deal?
Not if that property is going to be in that same LLC, right? So if you're going to have that same property and you're going to have now 2 properties in that LLC, that's perfectly fine to do. If you're going to separate it out and have a separate LLC, then I would take money from that as a distribution to yourself, then put that into that LLC as a capital contribution into that new LLC and use that money to then, as your down payment to purchase the new property. So it's all in the order and how you do it, right? So, and again, remember, the only time anybody's going to be looking at this is if somebody sues you and they're trying to look at it and try and decide they're going to pierce the veil, right? It doesn't happen very often. Really, you have to kind of piss somebody off really bad for them to want to come after you that bad, because it's expensive. They have an uphill battle to prove it, and so they generally don't go there. But I've seen it. I mean, they'll sometimes people get mad enough. They'll, as a matter of principle, they'll just go after you. So.
But you said, did you say earlier single member entities are getting the veil pierced?
Yeah, some bankruptcy courts are disregarding them, saying we're not even going to consider that to be a valid entity.
So only for bankruptcy court so far in Idaho?
So
not
far,
for...
I have not seen it on the level of just a general judgment creditor. It's generally only in the context of a bankruptcy court.
So single member LLCs inside of IRAs, those are not looked at?
Generally, no. It's a great way of doing it. Generally, when you look at it, where's your money at? A lot of times your money's in your retirement accounts, right? And so you can do, working with, I think the only local one that does it, I think, is Mountain West, right? You guys? Yeah. So you can take and do rollovers, get that money over, create an account with Mountain West IRA, and then you can take that money. We create the LLC, right? The LLC is hand in hand with the account, right? And we work generally with you guys to make sure we're doing the underlying formation of the LLC and getting all the language in the LLC that you guys want to see, and then from there, then the property gets purchased into the IRA, and you can manage it. There's some very strict rules on the IRA, on the IRS side, on how that can work, but it can be a great way to get, because that may be the only place where you have money to be able to fund some of these desires to purchase property. Now, one thing that you all need to be aware of is the new Secure Act. So the Secure Act passed as part of the budget bill on December 20th. It radically changes how your retirement accounts work for your beneficiaries, okay? So before, if you left, you die, you left the beneficiary to somebody other than your spouse. Your spouse still gets to roll and do what they want to do with it. But say you leave it to your children. Before, your children could stretch it over the remainder of their life expectancy. So they could, let's say they inherit it when they're 40, well, they can stretch it and allow it to continue to grow. The Secure Act now takes that completely away. If they inherit it, they have 10 years to liquidate that account. Unless they're minors or disabled individuals. And so what it's doing is it's funding the federal government quicker. Okay, that's Steve being a little cynical. But you think about it, the new tax bill reduced taxes on corporate entities and on some individuals. But they're still spending at the federal government level, so they got to get funding somewhere. So they figure out, well, gosh, we have all these people who have IRAs, 401ks, all these retirement accounts. Why are we letting them send it to their children as beneficiaries and letting their children stretch it out over their lifetimes? No, let's end that. Let's make them pay it out over 10 years. So what's going to happen is, let's just think through it. If your child's making even just a reasonable wage of, let's say, $60,000 a year, but all of a sudden you have that retirement account that has $500,000 in it, they got to start taking that money out. They don't have to. They could wait till the 10th year and pay it all in 1 year, but usually they're going to take it out over time. It's going to run them up through the federal tax brackets to some of the higher tax brackets, and so they're going to get more money into the federal government. Now, there are some positives to it. It increased the required minimum distribution age to 72. Did away with the limit on age, right, for when you can contribute as long as you're still working.
As long as you have earned income.
Earned income. It allows for some contributions out of a 529 account to pay for student loans up to $10,000. And it allows small business owners to pool 401ks. So small business owners, it's kind of expensive for them to do their own 401k. Now they're allowing them to be able to pool them so that they can spread the cost over multiple businesses. So there are some positives, but the big downside is that 10-year rule. That it all has to be out at 10 years. So
Especially since the way they worded it, it also affects Roths, even though they
Exactly.
get no tax benefits from.
Yep, the
making
Roth has to
people
be out of
into
it as
the
well.
Roth.
yeah, so it passed the House of Representatives 417 to 3. That tells you that none of them read it. Okay. We know that they didn't read it here in Idaho because we reached out to them and they said, "Oh no, we just relied upon what our staff told us." It's like, come on, guys. That's why we send you up there, is to pay attention to what's going on. We didn't think it was going to pass the Senate, but then, as all law, it got pulled into the budget bill and got passed kind of behind the scenes. And so, it's just you should never watch sausage and law being made because they're both it's very ugly. It's crazy. So, let me see if there was any other questions we had.
Actually, I had one small follow-up.
Go ahead.
You mentioned taking a distribution out of an LLC. Is there something special about that? Obviously, it's a taxable event.
Sure. I mean, so you can, once your rent monies come into your your LLC bank account, as you take distributions out, that's just paying it from that account to your personal account. That's a distribution. So, and your CPA will track that for you, as to, they're going to look at what your expenses you have and all those types of things. And
would I be required to prove that it's not commingling of funds, submit some documentation for that?
I mean, it's generally just, if you take that money out, you put it into a personal bank account, and then you take that from the personal bank account and use it to set up a new LLC. So that's going to be the chain, you've now created the paperwork to show that you haven't commingled it, because it come into your personal hands first, and then you took it there and set up a new LLC. Now, could you take that money, go buy the property in the existing LLC? You could, okay? So now you have two properties in that LLC. But then say you look at it and say, gosh, I don't want to have two properties in that LLC. So you go and set up a new LLC, and then you could assign the interest from one LLC, do a quitclaim deed, transfer the property over into the new LLC. You could do that. And it's just a matter of the order of priority of how we do it, to make sure that we're doing everything we should do.
And I think on the simple level, a cash distribution from your LLC is an okay thing.
Yeah,
If that's
absolutely.
what you're asking also. Like, it's okay to just do regular or sporadic.
Absolutely.
There's no rules on when your LLC can pay you. It's just labeled from an accounting when you label, this was a repair to the AC, this was utilities, this was rental income, this withdrawal was a cash distribution.
Yeah. And your tax account is going to track that for you.
Isn't it income?
And you won't get another tax when it hits your personal account because it's already been taxed as income through the LLC. So it's it's okay if you put it in some bank account that you don't follow as
Should be
much.
Next question. Does use of a property management company reduce owner liability, and are there special ways to do that? It can. I would say that you want to, again, vet the property management company carefully, and then make sure that the contract that you have with the property management company is, it very specifically delineates what each party's responsibility is. If you want the property management company to take on more of that liability, then make sure that the contract assigns that liability risk to them. And so it's just a matter of looking at the contract and making sure it does what you need it to do.
So if I own 4 houses in Cincinnati, do I have to fly there every time I do an eviction?
No.
If I have an LLC?
Well, if you hire a property management company, then no, because that property management company can do the evictions for you. But if you are the owner, the member of the LLC, then generally, you'll have to go every time. So here's the downside, and Idaho's just as bad as anywhere. When you go to do an eviction, the court's going to look at you and say, where's your attorney? Because you're an LLC. LLCs have to be represented by counsel. They can't be represented by the underlying members. And so you will have to have counsel to represent you. And most states, that's the same. So that's why a property management company is nice, because you can assign that responsibility to the property management company, and then they can step in and represent.
Or if you're the trustee of the trust.
Trustee of the trust, you do not have to have counsel for a trustee of a trust. You can represent yourself. It's just on the entity side. The legislature took a very interesting stance there. I disagree with it. I actually think that you as an underlying member of your own LLC should be able to represent your own LLC. But the legislature's taken the stance that they don't want that. They want you to, the only time they'll allow you to do that is in a small claims action. Small claims you can, but otherwise they won't allow you to do it.
I've done a couple of evictions, and it's been a while, and this was in Canyon County, but I remember thinking, because I don't have a property manager, and it said on there, too bad, even if you have a property manager, you as the owner have to be the one to show up in court.
Yeah, I don't know how long ago has that been, because I was.
Maybe 3 years?
Yeah, they should have required you to have counsel. So, because I just did one in Canyon County about 2 months ago, and it wasn't me because I was there representing the client, but there was another not a property manager, a property owner there, LLC owner, trying to evict somebody, and the judge said, "Sorry, we're going to have to reset this because you have to have counsel to represent you. Can't allow you to do it." So, it may be how you prepared the pleading too. Because if in the pleading you didn't by chance maybe have the LLC listed, or you just have the name of your company but not the LLC ending, judges sometimes they don't pay attention to the details sometimes, and so they may have just went forward with it because they didn't realize you were an LLC. And so
my mistake by putting my name there, even though it's an LLC, would be that would pierce the veil because I didn't put the name of the LLC.
Potentially, yeah. Yeah, you have to be real careful with that. If somebody would have to, if they were suing you on a piercing the veil, they would have to pull that evidence in and say, they somehow would have had to known that you represented yourself instead of your LLC. Chances of that are a little bit slim of them being able to know that. But yeah, anytime you have an LLC and if you are representing and you're there in your personal capacity, you could pierce that veil. So.
My question that I asked you earlier
Sure.
was about joint tenants with rights of survivorship.
Yeah.
Happening often within a family.
So joint tenancy with right of survivorship. So in Idaho, we don't see joint tenancy with right of survivorship a lot in real property transactions anymore. We see it mostly with bank accounts. Most bank accounts, if you have a joint account, it's a joint tenant account. But you can still own real property as a joint tenant with right of survivorship. So joint tenancy just says that, hey, you have two people that own this jointly, okay? The implication of that is the survivor of that, if one of you dies, the survivor gets the property. I mean, that's really the right of survivorship portion of it. Your question had to do with owning with maybe an individual that's elderly.
Right.
So the risks that we have there are, obviously, if you own it, they get dementia. They don't know who they are. Does somebody have a power of attorney to step in and represent their interest, right? To be able to speak for them. The other thing is do they need to qualify for some kind of a government benefit, Medicaid, Medicare? Sometimes those can implicate. They'll look at that and say, well, that's their asset. Even though you may be a joint owner on there, they're going to say, well, they're 50% owner of that property. And then it could disqualify them from being qualified for Medicaid, but it could also implicate the property if they die and they've received Medicaid benefits. Medicaid has a right of recovery, so they can come and force you to have to pay out the value to the extent of that person's value of the property. So generally it's better not to own it as joint tenants. The other risk is what if they had a creditor claim, right? The one I've seen very often is grandparents set up a joint tenant account with a grandchild. Grandchild goes out and does something stupid, and now they've got a judgment against them. It was not the grandchild's money that funded the account, it was grandparents' money, but now the judgment creditor can come and take that money because they're a joint owner on the account. So it's not the best type of ownership. It was actually the type of ownership we had here in Idaho before we had community property. community property came in and really kind of took over dealing a lot with joint tenancy, but that's how spouses used to own their property. Oftentimes it was joint tenant with right of survivorship. So
Is there a better way?
generally, I would say using an LLC, even if that elderly parent or elderly family member is just a member of the LLC, at least you can be the member of the LLC and dictate what's going on, or manager of the LLC and dictate what's going on with the LLC, and they're just a member interest, and so it's a better way of controlling the property.
You still have a liability concern if they go into long-term care? Or?
Still a liability risk there, yep, because they still would have to list that as an ownership interest. So where I deal with clients, so Medicaid is everybody knows what Medicaid is, right? Medicaid is especially for individuals who need long-term care, it's kind of the payer of last resort. So Medicaid is going to look at it and say, okay, do you have any assets? If you have more than $2,000 in cash assets, you don't qualify. If you have more than $2,813 in income, you don't qualify. But for people who didn't plan and need to go into long-term care, once they spend down all their assets, then Medicaid will step in and pay for that long-term care for them. But they're going to put a lien on anything they own, and then they have a right after their death to come and execute against that lien. And they sit in first position, other than mortgages. Mortgages sit in first position, but otherwise they sit in first position. And Idaho is one of the most aggressive states in going after collecting on Medicaid liens. And so I have created irrevocable gifting trusts for people for Medicaid qualification, but we need to know that they have 5 years before they need to qualify. If we can do that, then we can move the assets out of their name, but they can still benefit from those assets. And as long as we get past 5 years, then the trust isn't even looked at for them qualifying for Medicaid benefits. And it's so a way that the family could still maintain a property. I'll give you an example. I had a property over here in Cloverdale and Victory. And it's about 3 acres sitting right on the corner. And Dad had severe dementia. Mom's was fine, but her health wasn't great. And we looked at it and said, man, that's going to be a valuable piece of property that eventually is going to be developed into a commercial piece of property. And if he needs to qualify for Medicaid, there's no way that he can continue owning that, so we would have to sell it and liquidate it. Well, he happened to have a very good long-term care policy, and so we felt like we were able to get past 5 years, and so we structured the gifting trust, and he actually ended up dying before 5 years, so it didn't matter. But we would have gotten past the 5 years, he would have qualified for Medicaid, and that trust would have held that asset, and it wouldn't have ever been exposed for Medicaid recovery purposes. But it's tough to know when you have enough time, right? Especially with dementia and some of these other these diseases, we don't know, and so it's kind of tough. So I tell my clients, when you hit 70, and if you still want to have investable assets or real property in particular, then let's start having the discussion of, do we need to structure